President Trump's attorney Rudolph Giuliani has been suspended from practicing law in the state of New York. A 33-page order from the Supreme Court of the state of New York said Rudy Giuliani, a former prosecutor and mayor of New York, violated rules of professional conduct with his advocacy of claims President Trump was cheated of victory in the 2020 presidential election. He was admitted to practice law in New York in 1969. The order read, "There is uncontroverted evidence that respondent communicated demonstrably false and misleading statements to courts, lawmakers and the public at large in his capacity as lawyer for former President Donald Trump and the Trump campaign in connection with Trump's failed effort at re-election in 2020. These false statements were made to improperly bolster respondent's narrative that due to widespread voter fraud, victory in the 2020 United States presidential election was stolen from his client." The court concluded Mr. Giuliani's conduct threatens the public interest. Senator Tim Scott said Wednesday that a bipartisan group of lawmakers has worked out their main differences over a bill that will propose changes in policing and could reach a deal as soon as Thursday. Senator Scott of South Carolina, the top Republican in the talks, told reporters, "We're going to have to now check the definitions and the language that we're putting on paper to make sure that we're all saying the exact same thing. But I don't think there are outstanding issues that need to be worked out. We just need to agree on the actual language we're using." Senator Scott and Democrats Senator Cory Booker of New Jersey and Representative Karen Bass of California have been trying to reach a deal before Friday, when the Senate is scheduled to go on a 2-week July 4th break. They previously missed Joe Biden's challenge for an agreement by the anniversary of George Floyd's death May 25, and pressure has been growing to reach a bipartisan agreement that can pass the evenly divided Senate. However, Representative Bass was less optimistic Wednesday morning, putting the chances of working out a deal by the end of the week at about 50-50 in an interview. It was not clear how the sides are proposing to handle the most contentious issue in the discussions: demands by civil rights groups that Congress eliminate a legal doctrine called qualified immunity that makes it difficult to file civil suits against police officers. Under qualified immunity, plaintiffs have to show that officers knew that their conduct would violate a person's constitutional rights. In 2019, for instance, the Ninth United States Circuit Court of Appeals took up a qualified immunity case from Caldwell, Idaho. Even after a woman gave police there the keys to her home so they could look inside for her ex-boyfriend, a SWAT team bombarded her house with tear gas, causing extensive damage, and didn't find him there. The court ruled that because there had been no previous court ruling saying specifically that bombarding a home with tear gas was a constitutional violation, the officer had qualified immunity.